All rise! Shelby County Circuit Court's now in session. Honorable Judge Reed beginning, presiding.
Did you hear it? Be seated, please. Let's get you at council table since you're going to be engaging in some oral argument. I think he needs to be present with his counsel. There might want to be some discussion as we go through the process. Tell the clerk to announce that we might be a few moments late starting. As late as 9:30 this morning, there had been additional filings on behalf of both parties, and perhaps I need to go take a speed reading course so that I can move through it quicker, but in fairness to all parties, I wanted to give due consideration to the matters that have been filed in this case. The initial part of this hearing is reserved for one issue only, and that's the motion for the court's recusal, because the rules are quite clear that until that is resolved, I cannot have any further action in the case. So your argument will be confined to that, probably be a short recess, and then I will make ruling on that. In the event that I am not recused, I will then proceed, unless I stay myself, which is unlikely. The rule provides that I can stay the case or the Court of Criminal Appeals can stay. I think it's imperative to keep this case moving. So in the event that I am not recused, I don't intend to stay any action by this court. I'll go ahead and let you know that on the front end. I don't think that comes as a surprise to anyone. So I'll give you an opportunity to speak over here on the issues that are solely confined to the court's recusal. I will take a brief recess to try to gather my thoughts, and then I will make ruling in the open court with the findings of the court. Okay? Ready to proceed, Ms. Thompson?
Yes, sir.
And I'm going to also, I will apologize in advance. I've probably done it before in discussing matters with her. I've got two Jennifers, and sometimes I'm calling her Jennifer Nichols. I've probably called you Jennifer Thompson. I apologize. I clearly know the difference between the two actors, and it's just sometimes the wrong thing comes out of the mouth, okay? So, Ms. Thompson, the court will be pleased to hear you.
Yes, sir.
I've even drawn myself a chart. I write the name of grand jury for people so that people that I've known for 20 years, I won't suddenly forget their name. So I've got you charted, but I put you in the wrong seat, so I've got errors. So hopefully that will prohibit misidentification. All right.
Yes, Your Honor.
Ms. Thompson, the court will be glad to hear you.
Well, I'd like to put some proof into the record, Your Honor, so
Okay.
that I could make proof in the record. I'd like to call Erin Honeycutt at this time.
Okay.
She was my assistant, just to put proof in the record as to what was the substance of the telephone conference that morning.
Okay. State have any objection?
No, Your Honor.
I'm going to let you put that proof in the record. In the future, any telephone conferences, she ought to be identified as being present, because I specifically identified who was present on that call and who was not. And maybe it's oversight, but there was nothing whatsoever that would identify her as being present, taking notes, transcribing, anything else. Okay?
Yes.
Come around, be placed under oath where you see. I'll do it. I'll do it. Up here. Raise your right hand, please. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. All right, be seated.
Would you state your name for the record, please? And how is it that you're employed? Okay. And so on Tuesday, January 23rd, were you aware that there was a telephone conference set up between the parties in this case?
The date, again, I know it's all throughout.
24th.
24th.
January 24th.
Okay, which was a Tuesday.
And were you on that telephone call? How was it that you came to be on the call?
I called into the number that had been emailed out the day before.
And what was the purpose that you were on the call?
Take notes.
Okay. And are you usually present on telephone calls?
Yes,
Okay. And did you in fact take notes on that day?
I did.
And how is it that you took notes? What program did you use to take notes into?
Clio, an operating system that has a calendar, and you can just click on the day and time, and the event was the conference.
Let me say, acoustics are not very good. Mr. Walker just squeaked his chair. I'm not going to tell you not to squeak, but you need to speak up a little because acoustics are not good in this courtroom.
It's an operating system called Clio.
Okay. And what kind of system is that?
It calendars events, it holds all of your case matters, communications, calendar events, time notes.
Okay, so when you put these notes in, what kind of little section then did you put these into?
It's just a description box at the bottom.
For the event?
For that event.
Can you explain what an event is?
The event is a marker on a calendar.
Okay. And I'd like to pass that to you. These are
They were attached to a pleading.
do you recognize what it is that I've passed to you?
I do.
And what is that?
These are my notes from the teleconference on January 24th.
Okay. And you took them while the conference was going on?
Yes.
Have you edited them since that time?
No.
Okay. And so, while you were on the telephone call, and you've taken notes, can you please, for the record, tell us what it is that you recorded there in your notes?
Do you want me to go through kind of the...
Yes.
Okay. So I connected in on a call, and Jennifer, Luke Evans, Jim Simmons, Chief of Legals, Eric Christensen, Steve Ragland, Paul Hagerman, and Joe McGinley were there, or came in on the call. There was a remark about Susan, and then it was quickly discovered. Somebody said Danae Marianne, and it was quickly discovered that it looked like two parties were on the same line, and so the other party hung up. And so then the judge stated that he invited Susan Jones in on the call, but she had a death penalty case in Upper East Tennessee. He then said that the reason for the call was that he had approved, after a pretty, he was going to say about 20-30 minutes conference with Jennifer and Jim, a third attorney. Technically, it's not in compliance with the Supreme Court rules, but they had a good argument, and that was the Dillon Luke case. They suggested Luke come onto the case because it would take less time for him to get up to speed because of his involvement with Shane Austin. And under the immunity agreement, it was in the process of being revoked at the time of Shane Austin's death. But he did have two questions, and he'll give Jennifer and Jim a chance to make sure that he's right. One, do they understand that April 3rd is the trial date if there's no plea? And then two, what about the conflict of interest? He indicated Luke assured them that there was no conflict in further communication, and further communicated that with the Board of Professional Responsibility, and it had been confirmed. He issued an order saying that Luke could defend Zach. It was up to the AOC to decide if it was in compliance for purposes of payment for indigent attorney fees. This is Tuesday. The judge was supposed to have a car procedure, but not now, and he was doing carpus. As of Friday, the AOC had not approved it, told Debbie Tate, the director of AOC, was rejected. What was to occur was that then it would be submitted to Bivens for members of the Supreme Court to decide if they go beyond two death qualified attorneys. As of Friday, it was not approved. Mr. Evans had submitted his bill. Judge McKinley approved it, but not paid. But it has not been paid because it's not yet been approved. And then he asked Jennifer and Jim, is that accurate to this point? Jennifer said yes, that she did not know about the not approved part. And then the judge said, as far as the background of what he did, is that accurate? Jim Simmons says correct. And the judge asked, did anybody have anything to add? Jennifer said, get the conflict of opinion from the board before submitting. Also, the client signed a waiver of any potential conflict. The judge said, I did not understand that. So then Jennifer said, Zach Adams signed a written waiver of potential conflict. So the judge said, fast forward. I got a call from Jennifer Nichols on Friday. She said she was worried about a conflict. I know they said the board says it's okay. She didn't raise. BPR might result in censure of some type of warning, but we're in a new dimension when we're dealing with the death penalty. I told her to discuss with Jennifer and Jim and see if there was a way to work around that. That was not able to be accomplished. Jennifer Nichols expressed she's concerned about the settlement negotiations with the appearance of conflict. Jennifer Nichols, is this accurate? Jennifer Nichols says, you are. I did speak with Jim Simmons and advised my concerns over the issue after I spoke with you on Friday. I spoke with Jim on Friday and Saturday. Jim Simmons said there was no resolution. We don't think there's a conflict. Zach Adams signed a waiver of conflict. He would be deprived of his right to have Mr. Evans represent him. The judge said, well, not deprived representation. Evans may be pro bono. Jennifer Nichols asked the judge, do you want the prosecution team to set out for your honor in advance what our concerns are? The judge then said, I think the appearance of conflict is so strong, it makes it apparent Evans is no longer going to be able to represent Zach. This might reflect poorly in the confidence of judicial procedure. I'm going to disqualify Evans at this time. Prosecution, Judge then said prosecution make the order and my findings in the appearance of poor confidence in judicial procedure. Then Jennifer said, Your Honor, we had this hearing, not on the record. I request to have it again on the record. The judge said we will have it on 3-1, but hope to wrap the case up by then. Jennifer said, I'm going to want to file an appeal on this. This is an appealable issue. The judge said you can be ready for whatever on 3-1, making an interlocutory appeal, and I'll rule on it. My strongest suggestion, if no negotiated plea before then, be ready for trial on 4-3, April 3rd. And Mr. Evans is invited to attend. Jennifer Nichols then said on February 1st, put it all on the record. The judge said yes, it still remains. If I were representing Zach Adams based on the movements and what the court has been led to believe occurred, like I said 3 months ago, if if I were defense, I'd be beating down the door at 101 Poplar to see if I can get something reached. Any way to resolve 2-1 it needs to be. And the call ended at 10:15 a.m.
And do those notes reflect your recollection of what was said on the call?
Yes.
And so that's all I have for her.
Ms. Honeycutt, you've been present on the telephone from counsel, the judge, and the prosecution.
Yes.
You take notes of those as well?
Yes.
So I'm sure that you've heard for at least the last 2 years, the judge encouraged all parties to engage in productive settlement negotiations. Haven't you?
Yes.
You've heard him say that from the bench.
Yes.
Do you take notes during court?
Yes.
Okay. So then you probably actually heard him say that exact phrase before, either on the bench or on a telephone, where he encouraged people to come to Memphis, to my office, and engage in settlement negotiations.
No, I don't.
This is the only time that you wrote that down.
I think this is the only time I actually heard you say that.
And you would agree then that on this particular teleconference, the one on the 24th, you heard the judge take a roll call, didn't you?
I did.
Okay. And you heard me identify the 4 attorneys from Memphis, right?
Yes.
You heard Ms. Thompson identify herself.
Yes.
Mr. Evans identified himself.
Yes.
Mr. Simmons identified himself.
Yes.
And you chose to remain quiet.
Usually,
I'm sorry, my question, you chose to
I
remain
was
quiet.
muted. I was muted.
So in answer to my question, you chose not to answer the judge's question about who was present on the teleconference.
Correct.
And have you also done that same process on every other teleconference that the judge has had with the defense counsel and with the state?
I'm usually physically in the same place with Jennifer and the calls on
I'm sorry,
Zoom.
but maybe my question's not clear.
Yeah,
Have you
I'll
also-
never directly address the court, no.
So every single time that we've had one, you have remained quiet and not responded to his honor's question.
This time, I don't remember a roll call before, but yes, that's correct. I remained quiet.
If you don't remember a roll call, that's fine. So I'm going to ask you another way. Have you ever identified yourself as present on the teleconference between the judge and the defense counsel?
Not that I remember.
One moment, Your Honor.
Address something else. You've got my telephone information. You've got my office. You've got my cell phone. You've called on many occasions for scheduling purposes. No discussion of the case, just scheduling purposes. Is that what all of those conversations have been for? Is scheduling purposes? Has there been ever any ex parte communication concerning any of the factual matters concerning this case?
No, Your Honor.
All right. Anything else?
I do have a follow-up question. Besides yourself, were there other people from the defense team that were on the call that day that you're aware of?
Yes.
And who was that?
I know Amber Trees, an investigator, was on that call.
Okay. No further questions.
And for the record, I did say 101 Poplar. It's 201. But I remember I misidentified in that call. But I think the intent to urge settlement discussions is what the court was getting at, to encourage settlement discussions. And everyone in Shelby County knows about 201 Poplar, and that's just was an easy way to make reference. But I did say 101. So, all right. Anything else with this witness?
No, Your Honor.
Step down.
Your Honor, in this case, we are asking that the court recuse itself. This is a death penalty case which has a heightened standard of due process. The telephone call that the court, in the telephone conference which the court disqualified Mr. Evans, the court made several comments. One of the things that the court said was that it had spoken with Jennifer Nichols, and that Jennifer Nichols had raised concerns about the conflict with Luke Evans, the fact that that is more than simply scheduling, Your Honor. She raised concerns that that Luke Evans had a conflict. She also mentioned the fact, she expressed that she was concerned about settlement negotiations and the appearance of a conflict. And Your Honor, those things that were discussed are more than simply scheduling issue. They are ex parte communications that the court had with the state. And that it's not allowed under the rules. And it would give, the court disqualified Mr. Evans based on the fact that it would erode the public's confidence in the judicial system. And because the court in this case had extrajudicial communication with the state when the defense was not present, then that in and of itself, Your Honor, would be a reason to disqualify the court. The second reason would be that the court said, based on the very statement, based on new developments in the case, and what the court has been led to believe occurred. Like I said 3 months ago, if I were the defense, I'd be beating down the door at 101 Poplar to see if I can get something reached to resolve the case. And Your Honor, based on that statement, that the fact that it's not simply encouraging the parties to negotiate in settlement discussions, it is specifically giving an opinion that if the court were the defense attorney, and it also says based on what the court has been led to believe. So therefore, the court has some information. Based on that information, if the court were a defense attorney in this case, the court would certainly think that it's appropriate and necessary for Mr. Adams to be working out a plea deal in this case. And that's clear to the public. And the standard in this case, the standard that the court uses, is not what does the court know or what the court believes, but when you're looking specifically at the standard regarding a court's recusal, then the standard is what would an ordinary person in the public believe after seeing that statement. And it's clear that an ordinary person in the public is going to believe if the judge has said, you better be beating on the door of the prosecutor's office, and it's clear that the court believes that it is necessary, prudent, and probably...
Stop me just a second. As an officer of the court, how many times have I told you that it was not too early for negotiations? I told every single attorney in this room, they were present. Every time we've been in court, to my knowledge, I have tried to encourage the parties to negotiate towards some type of reasonable settlement so that this case may be put to rest. Will you agree as an officer of the court that I have done that?
Certainly, yes.
Right.
But when the court phrased it that way, it put a chill onto the defense team because it came across as though the court had made up its mind. The court thinks Mr. Adams is guilty, and the court thinks he should be working out a plea deal. And the second issue that I did raise in the motion for recusal is that the court has continually brought up the fact that there's not going to be a continuance of the April. Nobody at this point had asked for a continuance. Recently, I think we filed a motion that was ruled on in November, but nobody had asked for a continuance, and that also comes across that the court has already decided that issue as to whether or not it would grant a continuance, and that there's not going to be any reason for an exception. And again, having prejudged an issue, Your Honor, and expressed an opinion on that issue, then I think that's a second reason that the court should recuse itself. So there's three reasons, and when you look at the law and what the law supports in a case like this, that because the court has had ex parte communication, and even though it may have been slight, it's still the state expressed their concern about the conflict of interest issue, and they did more than just simply say, we need a hearing. They said, we're concerned, and we are, as soon as they add an and we are especially concerned about trying to enter into plea negotiations. That gives their opinion. They have communicated something to the court besides simply saying that they want a date to hear something on the record, or they need a date for a hearing. And because of that, Your Honor, we say that under the law, and the law is clear, that under the law in this case, and there's a heightened due process responsibility when a person is facing the death penalty. And there's case law that says that too, that in a death penalty case they have a heightened due process responsibility to have a court that is unbiased and that appears unbiased. And so based on those three reasons, Your Honor, we're asking that the court recuse itself.
I'll be brief, Your Honor, to address Ms. Thompson's concerns. One, about any extrajudicial statements that were made. Your Honor, I've been on the case over 2 years. From the beginning, you not only encouraged us to call you if there was a scheduling issue, you actually explained that you're out of your office quite frequently, being a circuit judge, and that everyone has your cell number. You gave it to us in chambers, all of the attorneys. When I realized that I needed a telecom or something perhaps set on this date, I did pick up the telephone. I called you. I asked if I could schedule a teleconference. And I don't know in what world Ms. Thompson practices in, but I've never set a hearing with the judge without telling him or her what the hearing was to be about. And I said I have a concern about Mr. Evans' representation of Zach Adams. That's as far as it got. And you correctly...
Would you agree that the total time of that telephone conference was less than 5 minutes?
I disagree. I think it was less than 2 minutes.
Okay. And part of that was dead time because I told you I was in a restaurant.
Yes, you went out to the car.
And total sum and substance, less than 2 minutes.
Yes, sir. Not only have I never, ever discussed the substance of the case against Zach Adams with Your Honor, I've never made statements about the case against Dylan Adams, nor Jason Autry to Your Honor. Ms. Thompson made statements that you must have some information about what other defendants would say or wouldn't say. I can't speak to that because I haven't, and no one on the prosecution team has had those discussions with you. There were no extrajudicial statements made by me to you. There was zero discussion about the substance of anything other than we had received a notice of appearance representation from Luke Evans. I contacted the defense, all of them, including Luke Evans, explained my concerns. We've attached the email string to a filing this morning between myself and the defense, Luke Evans' response, and then Paul Hagerman's response there too. When that didn't work out, I called for a teleconference, which is what Your Honor has instructed all counsel to do, and based on the statements you've made from the bench this morning, others have apparently taken advantage of that much more so than the state. I needed to voice the very real concern that we had about a conflict. I won't get into that now because I know we're talking about recusal. I think the second issue that Ms.
Negotiations.
Was negotiations. I've been on the case a little more than 2 years. From day one, every single interaction I have had with you, with defense counsel present, with you on the bench, with you in chambers, or a teleconference, with every defense lawyer, you have made the same type of statement. And the interesting part, though she is choosing to gear it towards some predetermination of guilt on your part, frankly, I took it as an admonishment to the state that we must engage in settlement negotiations if that was possible, because you wanted to keep things moving. You have never aimed those comments at one party in particular. You've advised all of us to talk. And in terms of coming to 201 Poplar, that's customary. We just all happen to be spread out. And that comment that was made about 201 Poplar, and frankly it's been made more than once, I think means nothing other than get together and talk.
At one time, I think I said, it's not too early to negotiate. Did I not?
Those are your exact words, but I believe you said them more than once.
Okay.
And this, I think Ms. Thompson made reference to 3 months ago, you're saying something. Your Honor, this has been going on for over 2 years that I've been on the case. And I can't speak to what you said before that, but I know what has taken place since November, December of 2014. And I don't have anything for you.
It's her third issue, continuance. You want to address anything on that? The statement of the court to stand firm in a trial date.
Well, I'm sorry I didn't address it because I frankly thought that's what your job was. You set this trial date months and months and months ago. And you, just like you've always encouraged us to engage in discussion, if appropriate, you've also said we're going to trial. And we all have...
Do you recall these exact words? And unfortunately, I was pointing my finger when I said it, that the court will try someone on April 3rd. At that time, there was no election, but I think those were my exact words, that the court fully intended to try someone on April 3rd.
You were so adamant about that, that the state felt that we needed to advise one of the defendants in particular and advise the court that that defendant was not going to be the first one that we tried. And that left 2. We felt...
Well, I think I stated that in open court.
You did.
Because the attorneys,
You were pointing at me.
Mr. Scholl and Mr. Parrish, came on board later than the other attorneys. And I think I said that theirs would be not before the second day.
Yeah. Right. Now that was said from the bench, but it's also been said on every telecon and in chambers. Until today, we have all met as a group, every single court appearance that I've come in the last 2 years, in chambers. And you've made the same statements.
Anything else?
No, sir.
Yes, Your Honor. Along with my motion, I filed 2 other items as attachments, exhibits. Exhibit A was the ethics inquiry email between Mr. Evans.
I've seen it. It's attached to your pleadings.
And I'd like to make that an exhibit to today's.
I don't know that we need an exhibit. It's part of the record because it's attached to your pleading.
Well, I'm thinking in terms of an appeal, Your Honor. I think in terms of the appeal, I'd like that and the waiver to be made exhibits to this hearing today.
It's already in the record. If there's an appeal, the pleadings will go up with the attachments.
That's true. In order to have separate exhibits, it would be duplicitous and more or less carrying the coals to Newcastle, wherever that expression started.
And the other thing that's happened is, Ms. Nichols has been basically testifying about things that occurred in the telephone call, but she's not done that formally. And she's been arguing facts that aren't in the record. And I would like to point that out, and I object to those coming in because they've not been made an official part of the record, and she has not testified to them.
She's an officer of the court, as are you. Okay? All right. Short recess. I'll make findings on the motion to recuse.
All rise.
He doesn't know about the little monitors, though.
Yes, he does. Yes, he does.
Court being recessed. Right here.